Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. Whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we're here to provide clear, practical insights. Now, divorce is complex, but understanding your rights and options can make all the difference in the world. While this isn't legal advice that I'm giving you, it's designed to empower you with the knowledge you need to move forward with confidence. Today, I want to look at high net worth divorces, the division of luxury real estate, whether a family mansion, a cherished family cottage, or a vacation home, often becomes a point of intense dispute. Protecting marital assets, particularly properties that have been in the family for generations, requires careful legal planning. Without proper safeguards, inherited homes may be subject to division as matrimonial assets. Picture this. A couple married 15 years ago. They built a life filled with luxury, a sprawling mansion in Toronto, a family cottage nestled in the Kawarthas, and perhaps a vacation home in the Caribbean. Their wealth accumulated through the husband's success as a corporate executive and the wife's inheritance from her parents seem untouchable. But when their marriage crumbled, the battle over their multi-million-dollar real estate portfolio became the centerpiece of their divorce. For the wife, the Muskoka cottage held deep sentimental value. It had been in her family for generations, a place where she spent childhood summers and where her own children have grown up. But because her and the husband had used joint funds to renovate the cottage over the years, the cottage was now considered a shared asset. Real estate acquired before marriage or inherited during the relationship isn't automatically protected in a divorce. Family law experts stress the importance of keeping assets separate, a mistake most couples end up making. If you inherit a family cottage, but you add your spouse to the title or you use joint funds for maintenance and renovations, you may be inadvertently converting it into a matrimonial asset. To protect inherited or premarital real estate, the following are highly recommended. 1. Prenuptial and postnuptial agreements that define property ownership. 2. Keeping inherited properties in trust or separate legal entities. 3. Avoiding the use of joint marital funds to maintain or renovate the property. Under the Family Law Act, a married couple may enter into agreements regarding their rights and obligations upon separation or divorce, as provided by Section 52 of the Act. Such agreements, including prenuptial agreements, can protect premarital assets from division. In the 2021 case of Murray versus Chaudhry, the parties signed a prenuptial agreement on May 2, 2007, the day of their marriage, which included provisions for the retention of separate property and the waiver of claims to spousal support except under special conditions. The prenuptial agreement was signed in Jamaica and was intended to shield the husband's property from claims by the wife, allowing his wealth to go to his daughter. The agreement was discussed and modified by the parties, but before signing, both parties also had independent legal advice. The legal issue in this case was whether the agreement signed by the parties was valid and enforceable, particularly in relation to the protection of premarital assets from being divided as matrimonial assets upon divorce. The court found that the agreement was valid and enforceable in Ontario as it was in writing, signed, and witnessed, and it complied with Ontario law. The agreement provided that each party would retain their separate property and neither would be entitled to seek equalization of family property upon separation, thus protecting premarital assets from division. The laws protect property owned solely by one party from any claim by the other spouse due to the presence of a valid agreement. thereby ensuring premarital assets are not being treated as matrimonial assets. In the case of Obin versus Kober, a 2021 case, they dealt with the legal issue of whether a cohabitation agreement protects the respondent's premarital assets from being divided as matrimonial assets, and whether it should be set aside due to non-disclosure and lack of understanding by the applicant. Under Section 56(4) of the Family Law Act, a court may set aside a domestic contract if a party failed to disclose significant assets or if a party did not understand the nature or consequences of the contract. The court found that the applicant was aware of the nature of the respondent's assets, including the home and business, and that the lack of precise valuation did not affect her decision to enter the agreement. The court also found that the applicant understood the agreement's purpose was to protect the respondent's assets, and she waived any claim to them. The agreement's provision that property would be divided by legal ownership was interpreted as a substitute for the equalization formula, thus protecting the respondent's premarital assets. In essence, the courts have shown that a cohabitation agreement will not be set aside, and the applicant's claim for equalization of net family properties will be barred, thereby protecting the respondent's premarital assets from division. Another effective way to shield inherited real estate from division in a divorce is to place the property in a trust or hold it under a separate legal entity, such as a corporation or family holding company. The Family Law Act provides that the value of property acquired by gift or inheritance from a third party after the date of marriage does not form a part of a spouse's net family property. Further, income from such property is also excluded if the donor or testator expressly states this intention. Property traceable to these excluded sources is similarly excluded. This ensures that the property remains legally distinct from the marital assets, preventing it from being categorized as shared property. For instance, in the example stated earlier, if the wife's parents had transferred the Muskoka cottage into a trust with the wife as the beneficiary, it would have remained legally separate from her marriage. Even if the husband had contributed financially to upkeep or renovations, his contributions would not automatically entitle him to a share of the property. In the case of Clark v. Reed, the courts dealt with the issue of whether a property placed in a trust by the wife before her marriage is protected from being considered marital property under the Family Law Act. Before their marriage, the wife conveyed her house to a trust with her husband as settlor and her brother as trustee, intending to keep it separate from marital assets. The trust stipulated that upon her death, the property would go to her daughter. The parties signed a marriage contract stating that each would hold their property free from claim by the other. The court found that the wife's transfer of her house to a trust before marriage was consistent with her intention to keep it separate from marital assets. The trust was established before the marriage, and the property was held as an asset of the trust throughout the marriage, thus not considered a matrimonial home or marital property. Keep in mind that even if an individual inherits a property, they can unintentionally convert it into a matrimonial asset if they use shared marital funds for upkeep, renovations, or improvements. In legal terms, this is called co-mingling assets, and it can jeopardize the inherited property's protected status. In the case of MNBCGF, 2019 case, the courts dealt with the issue of whether certain properties claimed as excluded should be protected from division as family property in the context of a divorce. The wife claimed excluded property of $45,500 from the sale of her interest in a condominium, which she purchased using proceeds from another condominium. The husband submits that current value of his RSPs and investments, $140,000, is excluded property, noting that the value was $144,000 at the time of cohabitation. The wife successfully demonstrated that the $45,500 from the sale of her condominium is excluded property, as it was purchased with proceeds from another property acquired before the relationship. While the husband established that his RSPs and investments are excluded property, as he provided cogent evidence of their value at cohabitation and separation, despite commingling the family income. The court concluded that the wife's claim for excluded property was valid, and the husband's RSPs and investments were also recognized as excluded property, thus protecting them from division as family property. Why is commingling risky for the parties? Well, if both spouses contribute financially to maintaining or upgrading an inherited property, a court may view it as joint investment rather than a separately owned asset. Courts may assess whether the non-inheriting spouse's contributions increase the property's value, for example. If the husband helped pay for a major renovation at the inherited cottage, he could argue that he has a financial stake in the property. Even indirect contributions, such as using a joint home equity loan to fund repairs, can blur the legal lines between personal and marital assets. For many couples, the battle over a Muskoka cottage is a painful lesson in asset protection. You never want to be in a position where you say, I never imagined I'd have to fight for my own family cottage. I just wish I'd known how to protect it before it was too late. As high net worth divorces become increasingly complex, the best way to protect luxury real estate is not during the divorce, but long before it ever happens. And these are painful lessons that clients learn all the time during divorce. Well, that's it for this episode of Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes, where we continue to explore the critical issues that matter most during your divorce. I'll see you next time.